Welcome to EstateCast. I'm Robert Newman. Our goal at EstateCast is to educate and inform you about estate planning and how it can give you and your loved ones a peace of mind. Today's topic is about parents and children. What is your relationship with your child and what is your relationship with your parents as it relates to estate planning? Your relationship with your parents and with your own children is important for several reasons, including developing an effective estate plan. Simply maintaining a loving relationship with a parent does not necessarily guarantee inheritance rights. A legal right to inherit depends largely on the legal relationship between a child and that child's parent. The existence of a valid estate plan, or if no estate plan exists at all, the applicable laws of intestacy in a given jurisdiction. Generally, children can inherit from their parents, whether their parents are biological or adoptive, but in most jurisdictions, there's no legal right for a child to inherit unless they are a minor, or it can be shown that they are accidentally left out of the parent's estate plan. In other jurisdictions, if there's no estate plan, a child may be entitled to a percentage of the parent's estate. Any discussion about estate planning concerns should include a review of the legal relationship between parents and children. In what matter are you a child of your parents? Are your children your biological children, or are they legally adopted? Are they stepchildren? Or is your relationship something else altogether? When it comes to a child's legal ability to inherit from parents, there is no difference between adoptive children and biological children. They are considered equal in the eyes of the law. However, situations involving stepchildren or presumed parents can be more complicated. So let's take a look at stepparents. A stepparent is typically someone who is married to or in a civil partnership with one of the biological parents of a child. With few exceptions, step-parents have no legal obligation to provide any legacy to a stepchild or their stepchildren. And unless they are legally adopted, stepchildren have no legal right to expect an inheritance from their step-parent. The ability of a stepchild or stepchildren to inherit from their step-parents can depend on the laws of the jurisdiction where the parents are located and the jurisdiction's laws of intestacy. For example, step-parents can choose to provide for stepchildren in their estate plan, and in that case, the stepchildren would benefit like any other beneficiary. If a stepchild is included in the step-parent's estate plan, under their will or their trust, that stepchild can inherit money or property in the same manner as biological or adopted children under the same type of instrument. However, if no provision is made for stepchildren under an estate plan, it is very likely they would not be entitled to an estate share. Previously, I mentioned the presumed parents. Well, in some cases, a person may be considered a presumed parent, meaning they are legally recognized as the parent of the child, even if they are not the biological or adoptive parent. Legal recognition for presumed parents is based on public policy that certain individuals should be treated as parents because they are, or of their relationship with a child and their role in that child's life. This is some of the criteria for being a presumed parent, and the criteria can vary by jurisdiction, but often include biological connections. In some jurisdictions, a person who is the biological parent of a child is automatically considered a presumed parent, regardless of their marital relationship or their marital or relationship status. Then you have a birth or adoptive parent. A person who is legally adopted or given birth to the child with their consent, of course, is considered a presumed parent. You have marriage or domestic partnerships. If a person is married to or in a legally recognized domestic partnership with the child's biological or adoptive parent at the time of the child's birth or conception, they may be presumed to be a parent. Then you have the intent of the parent. If the individual openly and actively takes on the role of a parent and demonstrates their intent to parent the child, they may be considered a presumed parent. This can include factors such as receiving the child into their home, providing financial support, making important decisions regarding the child's upbringing, and establishing a parent-child relationship. Finally, it's the length of time and stability. The length of time that the person has been involved in the child's life and the stability of that relationship with the child may be considered when determining presumed parenthood. The relationship between a child and a parent can take many forms. It is therefore important that you discuss with your estate planning attorney and financial advisors the need for an estate plan that clearly identifies your intent and your intended beneficiaries and the legal relationships of those beneficiaries to you. Your documents should clearly describe what is the relationship of those beneficiaries to you. Your discussion should also examine relationships with individuals who may not be immediate or obvious family members. A well thought out, comprehensive estate plan will allow you to feel comfortable and to have the peace of mind regarding your inheritance, and that it will also be clear and properly documented so they can be legally enforced. I hope you've learned something new today. As always, if you want additional information or to discuss your own estate plan, call us at 301-892-2713, 301-892-2713, or you can reach us at our website, which is www.estatecast.com, www.estatecast.com. We know that life is precarious. Our goal is to give you peace of mind by living with your bags packed. You never know what tomorrow may bring, so let's get prepared.